Welcome to Estate Planning 101. We only get one chance to die. There's no coming back for a redo if we mess it up. Probate can mess it up. So let's talk about it. What is probate? It's all the court proceedings that determine who gets what. Probate takes time, costs money, and is a matter of public record. Does a will avoid a probate? No. A will requires probate. Let me explain. If you don't have a will, your state has one for you. It means you die intestate. Chances are your children will get the lion's share of your estate after a probate, after the state peels off their share. So we want to avoid the nightmare of probate, if at all possible. Well, how do we do that? When is probate required? It's very simply when there's nobody left on the title. Mom and dad own assets as joint tenant. Dad usually dies 4 or 5 years before mom, and if you say it's because of the cooking, you're in big trouble. No probate because mom's name is still on the title. Then mom passes away. A probate is required to transfer the deed because nobody was left on title. Who benefits from a probate? Not you or your kids, unless they're all attorneys. Normally, an attorney becomes a beneficiary, and he's paid before everybody else. What a deal! How do we avoid the probate nightmare? Did you know Patrick Henry was the very first American to have a trust? When Ronald Reagan was the president, he made some changes in the tax law that kind of revealed that the revocable living trust can be a beneficial estate planning tool for us common folk. There are 3 parties to the trust: the grantor, the trustee, and the primary beneficiary. Well, mom and dad, you wear 3 hats because you are the trust maker or the grantor. You're also the trustee or the manager. And we're setting this trust up first to benefit you, so you become the primary beneficiaries. There are 3 parties in a trust. The grantor or settlor, that's mom and dad, they have all power. The trustee or the manager, the primary beneficiaries, which is also mom and dad. The successor trustee is usually 1 or 2 of your most mature children. We only recommend a financial institution like a bank if there's nobody else in the family that can handle that. However, banks and other trust institutions want a 10 or 20-year distribution so that they can leech off of that estate for many, many years. The heirs come later. We set the trust up to benefit mom and dad. The heirs benefit when they're gone. Can I amend my trust? Well, that's a big yes, because you have all the power. You can change it, you can revoke it, you can amend it. Why would anyone want to disinherit any of their children? Now that's a good question. And it does happen occasionally. Maybe dumping a wheelbarrow full of money into a child's lap could be the worst thing that could happen to them. What if they have a drug problem? We could restrict their inheritance. There are other reasons. I had a friend who was 31 years old when he inherited $400,000. Because he was now rich, the first thing he did was quit his job. 18 months later, he was penniless. He didn't have a car. He didn't have a job. He didn't have a house. So he moved his wife and 3 little children into a hotel where they lived week to week for about a year until he could get back on his feet. What a waste that money was to him. So you know your children. Sometimes we might disinherit a child for a period of time or restrict his distribution until he gets his act together. If that situation fits you, we can talk about it when we visit. So here you are, Mom and Dad, dancing on the stage of life, having a good time. And Dad thinks he's still back in the disco era, so he starts to bust out some pretty ancient moves, and he falls down and blows out his hip. Well, Mom is still able to dance, so she can manage the estate as the co-trustee for the benefit of her and her husband. But if Dad gets really crazy and they both go down, the successor trustee then steps forward and manages the estate for their benefit until they can continue to dance. But if the curtain comes down, dance is all over, Mom and Dad have been transferred, the successor trustee then can distribute the estate for the benefit of the heirs without any court or attorney intervention. Pretty slick. I don't say so myself. So we create with the trust a funnel or one pattern of distribution. The trust then, all of these assets look to the trust for distribution. So we make some changes on most all of these accounts. Some will pass by beneficiary designation like life insurance. But what doesn't go into the trust? Unless you want to pay tax this year, you keep your 401k, IRAs, and other tax qualified plans out of the trust. The estate planning portfolio consists of the revocable living trust. Now that your assets are held in trust when you pass away, we look to the title. Who owns it? The living trust owns it. It still lives. No probate. A last will and testament. Why do we need a last will and testament if we have a trust? This is called a simple will or a pour-over will. It doesn't have a plan of distribution. It simply says, if I've left something out of my trust, pour it over into my trust after my death. The healthcare powers and the living will, your right to die documents, general powers of attorney for financial decisions. The person you choose as successor trustee is normally, but not always, the same person you would choose as your executor on the will, your attorney in fact as it relates to healthcare and powers of attorney for financial decisions. Doesn't have to be, but it's kind of a convenient thing if that person or persons are the same. The tangible property list is for you to list assets that are important to your kids. So you can describe the item and give it to whoever you want. It passes outside of the trust. The trust nor your will has any power over personal property. So it's nice to leave a list behind that your kids already know who gets it so they don't fight over it. Guardianship for minor children. If you have minor children and you don't have a will that designates guardianship, normally the first person who petitions the court becomes the guardian, and that may not be your best choice. Let's talk about funding the trust. You are responsible to fund your trust. Let me explain. Funding simply means to transfer assets to make sure that all of your title assets are in your trust. A word of caution, when we establish the trust, we transfer your assets into the trust. But after that, if you were to purchase something, you need to purchase it
in the name of the trust if it has a title. If your name is Barbara or Bob and Barbara Jones, the name of your trust most likely would be the Bob and Barbara Jones Revocable Living Trust, created the date you signed the documents and have them notarized. So we fund the trust, but in the future, you need to make sure that you purchase assets in the name of the trust. The trust has no teeth or no power over assets it doesn't own. So you could have a trust and leave something out, and maybe there'll be a probate on that asset. So funding your trust is very important, but it is your responsibility. Your estate planning portfolio will consist of all of your legal documents that we've just talked about and your titles. That way, when you're gone, your heirs have access to this document, these documents. We call them a document of affection because they replace the hub of the will. Mom and Dad, you are the hub of the will. Your children are the spokes. And once you're gone, the least bit of emotional pressure or pressure from the legal system can scatter those spokes, and they may never recover. We place in that void this document of affection so that your children still have something to lean on. Because what we have discovered is that when mom and dad are gone, grief takes its toll. But grief is pushed off of the table when greed enters in. If the kids are aware about everything you've done, oh, it works so smooth, no pressure. Your kids don't even have to call an attorney because it's already done. If you leave your affairs to someone else, you're leaving a signed blank check on your estate, like Roy Orbison did. Now, attorneys think they're worth $500 an hour when you can look them in the eye. But when you're gone, they think they're worth a whole lot more than that. Now, we want to pay attorneys to do these trusts because we want to throw them a bone, a little bone, but not a big bone. So we use attorneys to create these documents so that it's done right, it's done legally, and then we don't have to pay them a second time. Now, my name is James Crocius. 3.5 years ago, we moved from Reno to Meridian, Idaho, because 4 of my daughters moved here all in the same year with 15 grandchildren. So we moved with them. The Revocable Living Trust is the most important document that we can use to keep our families together after we're gone. If we can help, our attorneys charge about 40 to 50% less than the average here in the Treasure Valley. So give me a call, send me a text, or email me. Love to talk. Thanks. Bye now.